Today, I will discuss how to maintain anonymity in public filings for limited liability companies, thereby shielding the identity of the natural person while maintaining full compliance with state and federal law. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the great states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University, and I hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. The double LLC structure is a legitimate and lawful legal strategy for business owners seeking privacy, liability protection, and operational flexibility. It involves the formation of 2 distinct limited liability companies, or LLCs. First, a holding LLC, and second, an operating LLC. The operating LLC conducts the day-to-day business activities, while the holding LLC owns and manages it. On public-facing records, the operating LLC lists only the holding LLC as its manager, and vice versa, not the natural person behind it. This layering technique makes it significantly more difficult, though not completely impossible, for the public to trace ownership through state business registries. By establishing an LLC in a state with minimal disclosure requirements, or by applying the double LLC approach that I am describing in this presentation, entrepreneurs and business owners can substantially reduce their personal visibility while legitimately maintaining compliance with state and federal law. This approach is especially appealing to investors, professionals, and high net worth individuals who value confidentiality and discretion without sacrificing legitimacy. Further, this is particularly useful in states like Florida and Texas, where the management information of a limited liability company is usually a matter of public record and can normally be accessed by anybody with an internet connection, thereby creating meaningful privacy risks and making LLC members and managers targets for unscrupulous scammers and the prying public alike. Let's talk about how the double LLC process works in more substantive detail. The process first begins with retaining an experienced attorney who will then form the holding company, followed by the execution of certain bespoke documents prepared by that attorney experienced in the double LLC strategy. The holding company serves as the manager of record for the second entity, that is, the operating company, which may be and usually is formed in the same state. For example, ABC Holdings LLC becomes the sole manager of ABC Development LLC. The records of the Florida Department of State or Texas Secretary of State will list only ABC Holdings, not the individual owner, as the manager in charge. Simultaneously, the sole manager of ABC Holdings LLC becomes ABC Development LLC. Therefore, the individual owner's personal name, address, and affiliations will not be publicly accessible on these records. Internally, however, meaning within the company, the same person owns and controls both companies through properly executed operating agreements and unanimous written consents. This 2-tiered design allows lawful and legitimate anonymity on public filings while preserving full ownership, control, and managerial authority through private documentation. Let's cover briefly the privacy and asset protection benefits. The primary benefit of the double LLC strategy is, of course, privacy. State business databases are public and easily searchable in many states. Listing a holding company, as I have described, rather than a natural person, breaks the link between your personal name and your business operations in the public records, while still allowing you to maintain full ownership and control privately. This makes it much harder for competitors, litigants, or online data aggregators to identify your assets or business interests. Another major advantage is asset segregation. If the operating company faces a lawsuit, only its assets are exposed so long as certain other formalities have been consistently observed. The holding company, which owns the operating entity, remains insulated. Likewise, if the holding company encounters a legal claim, the operating company's assets are generally protected. This compartmentalization further strengthens liability protection beyond what a single entity structure can legitimately provide. A third benefit is that of professional discretion. Landlords, physicians, attorneys, consultants, and investors frequently prefer to keep their personal identities separate from the businesses they operate or the properties they own. The Double-LLC model achieves this separation without the appearance of impropriety or concealment. There's also a strategic advantage in negotiations and acquisitions. Because ownership is not immediately apparent from public filings, potential counterparties cannot easily assess your personal wealth, other holdings, or financial exposure, which can meaningfully strengthen your bargaining position. Now let's talk about some of the downsides. Despite the many advantages, the Double-LLC structure requires disciplined and ongoing maintenance and documentation. Both companies must be properly capitalized, maintain separate bank accounts and corporate records, and observe formalities. Courts may pierce the veil if the entities are treated as interchangeable or used for fraudulent concealment or other illegitimate purposes. Owners must also consider complying with federal transparency laws, particularly the Corporate Transparency Act, which in certain cases requires disclosure of the ultimate beneficial owners to the Financial Crimes Enforcement Network, also known as FinCEN. While the structure may hide ownership from public view, it cannot and must not be used to conceal ownership from lawful authorities. The administrative cost is another burden worth considering. Two entities typically means two sets of annual reports, registered agent fees, and potentially two sets of tax filings, although there are some ways to work around that. The complexity is worthwhile only if privacy and asset protection are priorities. Finally, practical disclosure requirements remain unavoidable. Banks, title companies, and regulators may still require identification of the ultimate beneficial owner to satisfy anti-money laundering and know your customer obligations. The Double-LLC structure protects privacy from casual public inspection, but not from legitimate due diligence by proper authorities. When structured correctly and maintained with care, the Double-LLC model delivers lawful anonymity and discretion, operational flexibility, and stronger asset protection. It is not a tool for concealment or subterfuge, but rather a sophisticated method for safeguarding privacy in an age where personal data and ownership information are easily searchable online. By combining sound legal drafting with diligent record keeping, business owners can maintain both compliance and confidentiality, the best of both worlds. And the essence of modern corporate privacy and personal asset and wealth preservation, all of which should be top priorities for any astute business owner or entrepreneur. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.